what we'll be covering. The topic today is the introduction to intellectual property, the historical scenario of this intellectual property, how it started, when was it started, how did it come to India, and how we have come to the latest Patent Act now. What is the importance of IP protection? Why should you protect? What are the different types of intellectual property rights? Now, you get a patent right, then what are your rights? How you can use, what is the meaning of that? And they have asked for the trend in the Indian intellectual property filing in Indian Patent Office. And I have just added 2 or 3 case studies as examples, because for want of time, I have not added more case studies. With that, we will be switching over to the actual coverage of our intellectual property, this thing, and then. Now, when you see property, it could be any property. It will be either tangible or intangible. Under the tangible, what we have is movable and immovable. Intangible intellectual property is the only one. What we can see is tangible, and what we have as a is a movable property, but intangible is the intellectual property right. And under that category, if you see intellectual property, the different types of IPR. One is patents, then we have designs, then the trademarks, copyrights, geographical indications, plant varieties, semiconductors and layout designs of integrated circuits, trade secrets. The last 3 items are there for the past within a period of 1 decade, rather I would say. After 2009 or 10, it has started. Even geographical indications, after the turmeric case in United States, and then this rice, or what is that rice we call? Basmati rice. Basmati rice applications, we had the problem of why should you not protect the geographical indications, national heritage projects of our Indian country? And so we had the GI Act. Copyright was there since long time, but it was under the different ministry, and now it has been taken to that our Commerce Ministry, Commerce and Industry Ministry. And we had since beginning the patents, the designs and the trademarks. And when you see the actual intellectual property, it is basically industrial property plus the copyright. Why we say industrial property and then copyright is industrial property is normally connected with any company, a manufacturing company, a research organization, having marketable marketing department and all. Now you say a company, corporate, industrial property, it will have patents, designs and the trademarks. Then if possible, they also will have geographical indications. Now industrial property connected with the intellectual creations of your mind, that is a copyright, it becomes an intellectual property. Now patents, which is a department dealing with the patents matters. That is the Patent Office under the Government of India, Ministry of Commerce and Industry, DPIIT, Department for Promotion of Industry and Internal Trade. We have the office called Patent Office, and design for the Design Office, the trademarks for the Trademark Registry, and GI for the GI registry, the copyright, and we have our National Institute of Intellectual Property Management for training the peoples under these areas, and we have the copyright now added to the DPIIT, that is Copyright Office at Delhi. Now, once we say IP right for a product, say a camera, we can have all the rights. There are some inventions where you will get only one right, patent right. You may not be able to give and apply for a trademarks or what is called design right. But when I take an example as a camera, for this camera you can have all the four rights. How? We will have a look now. The patents for the individual improved mechanism. Now, all the participants, just think of your leave the secondary school examination, that is SSLC, or the 10th standard or the 11th standard. When you are leaving the 10th or the 11th or the 12th course of your schooling, the last day you will have a what's called a photograph with the college professors and the principal and the headmaster and the teachers. Good olden days, we used to have a tripod and a small box camera and the black cloth, and the photographer will take out that lid of the camera and expose and again close it. That was the thing. Now we have a camera which can work at a speed of 1/5000th of a second. If a basketball player is putting the ball in the basket, that time you can click the camera. Now the batsman is making a sixer, cross the thing or not. There is bowled, whether the ball has hit the stumps or not. You are able to have a replay, very close thing, everything. The camera is able to decide the thing, work so fast and find out the importance of that activity. That every individual improved mechanism of the camera is the subject matter of patents. Now, when we take the outer body, this is a camera, you have an outer shape, contour of the camera, the configuration of the camera. That is the subject matter of designs. When I ask you to name a few camera names, you will say Canon, Nikon, Sony, Pentax, like that. So that brand name or the logo, they are called trademarks. Now, when you purchase a camera from a shop, that manufacturer gives you an the instruction manual, a booklet, along with the camera, for which he has taken the copyright. Now, I will give another example, a pressure cooker. Now, you will be surprised what could there be 4 rights there in pressure cooker. Now, you will see the difference between the Prestige pressure cooker and a Hawkins pressure cooker. The Hawkins, the lid goes inside. The Prestige remains outside the lid, outside the bottom, covering the bottom. Now, that pressure valve mechanism is different. And in the latest pressure cookers, now I'll take the example of Prestige. You have inside a gasket. When the pressure increases too high, then there's a slit. That rubber gasket gives way, and the manufacturer has made the pressure to come out, so that if you have not switched off the gas or the oven, that something untoward should not happen. So such is a mechanism. So like this, each and every individual mechanism is a subject matter of patents. And now you take, as usual, that outer shape, contour, and the configuration of this pressure cooker is a subject matter of design. Now I take the brand name, Prestige, Maharaja, Hawkins, Unique, something like different names. They are all the subject matter of trademark. And as usual, the instruction manual or the booklet given by the manufacturer, that is the thing for which they have taken the copyright. Now, this is just to idea to give you how I can have different uh, property rights, IP rights for a product. Now, I will just tell you what is a IPR system in India. IPR, Intellectual Property Rights System, it comes under the Ministry of Commerce and Industry, Department for Promotion of Industry and Internal Trade, that is a department under which the subordinate office, the Controller General of Patents, Designs and Trademarks and Copyright has been added in 2016. So that is also coming under our purview. Now, below the under the control of Controller General of Patents, Designs and Trademarks, we have the Patent Office, the Design Office is at Calcutta, then the Trademarks Registry, then Geographical Indication Registry, then we have the what's called Patent Information System and National Institute of Intellectual Property Management, that is at Nagpur, and we have the Copyright Office at Delhi. Then we also wanted to have our own separate intellectual property appellate court, a dedicated court. So the appeals can be taken from against the order of the controller, of the design controller or patent controller or the register of trademarks or the register of GI or the register of copyright. So the IPAB was formed, established in 2003, and the composition, organizational setup is the chairman of the Intellectual Property Appellate Board. We have another judicial member along with the chairman, vice chairman, and then technical member judges for that patents, design, patents, trademarks, GI and everything. Now, we'll see only about that patent office, IPO in India. That is the Controller General of Patents, Designs and Trademarks. He is at Bombay. We have patent office at Calcutta. It was a head office since long time. And thereafter, now we have made the virtual offices at Mumbai, then Chennai, and then New Delhi. The idea is to have the application filed at, for example, Delhi. We will have examination, grant, post-grant activities, everything will take place in Delhi. Even you have a file at Calcutta, when you file the application in Calcutta, everything will be done at Calcutta. So every office becomes a virtual office. The Calcutta for the East Zone, Mumbai for the West Zone, Chennai for the Southern Zone, New Delhi for the North Zone. Then, like that, trademarks, Bombay, the head office at Bombay. Then we have at Chennai, Trademarks Registry Chennai, then TMR at Calcutta, then TMR at New Delhi, and then TMR at Ahmedabad also. That is a setup there. Then we have what's called a Geographical Indication Registry. Then we have the Patent Information System at Nagpur. Now it's joined with the NIIPM. And we had the Copyright Office inducted into the Ministry of Commerce and Industry, DPIIT, located at Delhi since 2016. So this is a setup of the Controller General of Patents, Designs and Trademarks organization. Now we will go to the next slide to tell you in nutshell what is IPR about. The patents protects the technological information, mechanism of a camera, mechanism of a pressure cooker. So the technological part of it is protected by the patent right. Invention of that is you apply for a patent and then you get a patent monopoly right. Then the aesthetic creation, aesthetic point of the camera, pressure cooker, outer contour, configuration, outer look of the camera or the pressure cooker is a subject matter of design where you will have no internal mechanism. For that, the design application is made at Calcutta. You can make it at Delhi, Bombay, and Chennai, but the examination will be done at Calcutta, and then you'll get a design registration granted. Like that, the goodwill of that is the brand name, logo, device marks, and label mark, service mark, everything is all about the trademarks. You file it in the trademark history. So the trademark protects the goodwill of the product. And geographical indication, it protects the heritage, and it's a community right. The patents, designs, trademarks, and copyright are all individual rights. Company can apply and get it, or individual can apply and get it. Whereas a GI, it is a community right. Yeah, association of persons, organization of persons, that they will apply and they will get the thing. Now, for example, a GI, it's a Kanjivaram sari. The producers of the Kanjivaram sari, the weavers, they will have an organization. That organization secretary or the commercial department of the Tamil Nadu, they will apply for that GI registration. And I'll give you some examples of GI later point. And now I'm just giving you the idea about the patents, designs, trademarks, and GI and copyright. The copyright protects your ideas and the concepts, but it has got to be expressed in the written form. Then only it will be accepted. Now you should have a clear idea the difference between patents and design on one side, the trademarks and copyright on the other side. Two 180 degrees apart. Now patents and designs, they are all called statutory rights. Statutory rights. Whereas trademark and copyright, they are called as common law right. Another basic difference is, in respect of patents and designs, you can never put it to the public knowledge. You have to first file it in patent office. Patent office or the design office should be the first person to know about the invention. You shall never put it in the put it to the public knowledge and then apply for a patent. No, it's not possible. So the registration is mandatory. Now, on the side of the trademarks or the copyrights, you will find is a common law right. You have to use it first, then you can register it. That is preferably 3 to 4 years or 5 years of use, prior use. It will be a very good point for getting the surety of registration as a trademark. Copyright, the moment you have written the thing, you have created, you become the copyright holder. So registration is not mandatory, but why do you require the registration? In case you would like to go for a litigation, you want to sue somebody who is copying your patent, trademark right or a copyright matter in the what's called court of law, then you have to show the proof as that you are the holder of the trademark, proprietor of the trademark, or the holder of the copyright. For that, you require the registration. Okay. Now, we will see about particularly the patents now. What is a patent? Patent is a monopoly right, intellectual property right as a monopoly given to you for your invention by the government. That is, government is granting the patent right, monopoly right. So it is for your invention granted by the government to the inventor or is assigning. Now I will give the example here. I am the managing director of the company. I have a R&D section, research and development wing, and X is the inventor. And he comes out with an invention. He grants, he applies for a thing, taking my permission, and the application for patent is done in the name of the company, the company where I am working as a managing director. Inventor as a true and trust inventor, and he assigns the right to the company. And on behalf of the company, as a managing director, I sign the application. So the company becomes the applicant, inventor becomes the assigner. And the patent is granted for a limited period. Now, according to the WTO standard TRIPS agreement, under the Indian law, we are granting for a period of 20 years. Once the patent is granted, it is valid only within the country of grant. Now, patent granted by India, by Indian government, it is valid only in the Indian territory, in the north and south and east and west of the Indian country. It is not even valid in the neighboring country, Nepal, Bhutan, Bangladesh, Pakistan, Sri Lanka. You want to file an application, then people they say normally, I have applied for international patent. That thing called international patent. When you want a patent right in the United States, you have to apply to the United States Patents and Trademarks Office. You have to make an application, they will examine, they will grant the patent. Now you want it in Japan, you have to apply to the Japan Patent Office. They will examine, they will grant the patent. You want a patent right in Australia, you have to apply to the Australian Patent Office. They will grant the patent right, and after examination, and that patent granted is valid only in Australia. Patent granted in United States valid only in United States. Now, you will put a question. Now, I am in India. I want to have a patent monopoly right in USA. What will I do? I can file in United States, but if you are an Indian citizen, with the Indian Patent Office permission, you can file, or you can file a Indian application, and based on that, you can file a corresponding convention application in the United States, or you can file through a PCT route. That is what is called Patent Cooperation Treaty. You can file an international patent application, then you can file a national phase application in the United States. So that way you can file in various countries. Now, we will have a look at what is called patents. What is patent? That is a Latin word, literae patentes. Meaning of us is an open letter. It is an open letter given by the medieval monarchs those days, conferring rights and privileges to the inventors. And there was a royal seal, and it gives us given as a proof that the so and so is a patent holder. And anybody, thou shall know that he is an inventor and he holds the monopoly right. Okay. Now, that being the patent system started like that, later on it went to that Italian country, and we had the informal system developed in Italy. Then it was slowly, it spread to the Europe level. When the Venetian glass blowers, they applied for a thing, and they got the monopoly rights, something like a guilds and then protection there. And then other earliest forms before 500 BC in Sybaris, that is southern Italy, now is Greece. They had a thing for new dishes for new dishes for that boat and other items, glass making, everything. Then that are all called a monopoly, sort of monopoly right, or I should say guild having a special rights like that. But everything's changed to patent form in the Roman Empire, where the guilds existed, and they said they started giving the patent form of monopoly right. Earlier, it was like a communal property right. Particular region was chosen, and there they had the monopoly communal property right. The first person was the Filippo Brunelleschi of Florence. He invented a new kind of boat where he can carry very good heavy loads of items. माल लेके जा सकते हैं. And he was to use that boat in that Arno River in southern Italy and Rome side. And that he got made an application, he got a patent form of monopoly right. In 1421, Lords of the Council of Florence, they granted an exclusive privilege to this Filippo Brunelleschi for using this boat on the Florence of to run the boat on the Arno River. For 3 years, they got they gave the monopoly right. Now, this patent system slowly, I think, it started into a form of a regular patent grant system. And England, they started that in UK. That is, in 1331, John Kempe, he applied for a patent, and then the patent was, which allowed the purpose of instructing the English in a new industry. Royal grant was made, and then they had the patent system originated there. Then Venice, they had the patent system, patent monopoly right granting to glass makers as early as 1420. After the 1331 in England, somewhere in 1420, we had the patents grant taking place at Venice. In 1474, we had the Venice came up with the first patent statute. Patent law was made in 1474. Then they had that 1443, the inventor bylaws was created, and then finally, and they practiced the patent law, the first patent law in the world. In 1449, King Henry VI of England granted a patent to John of Puttenham for monopoly right to make stained glass, the colored glasses, stained glasses, that one. And the basis of patent practice, actually, that it started in England. The statutes of monopolies enacted in 1623 became the basis for that patent practice. It went on for about almost 2 centuries. And the peculiar thing was the patent rights were granted for a period of 14 years. That practice was started in UK, in England. And I would rather say, once a patent right is granted, as a patent holder, I will stop all others. Thou shalt not manufacture. Now, only I will manufacture, and all others, they cannot manufacture, they cannot sell, they cannot copy, everything. So that is what is given here. Others shall not manufacture during the time of such letters, patent grants, and also shall not use without my saying. They can purchase that patented product and then use it. That is not a different. That's a different thing. But that actual technology, they can't use it. If they want to use it, they'll have to take a permission from me. I will give a license. Then you will be able to use it, and you will, for that use, you will have to pay me a royalty. Like that was the position. In 16th century, this legal system of patent became much more clearer as a common law heritage, including United States, New Zealand, and Australia. Now, in 13 colonies, inventors could obtain patents through a petition to a given colony legislature. In 1641, Samuel Winslow, he was granted the first patent in North America in the Massachusetts General Court for a new process of making salt in 1641 in America. Now, thereafter, every country started adopting the patent system, the patent law like that. United States, they did it, adopted that such a law in 1787 to protect the intellectual properties, and the first federal patent statute was created in 1790. In France, the patent law, the first patent law therefore in that country was enacted in 1791. In UK, the patent office was set up in 1852 for granting the patent, and that system went on for a long time. Immediately, there was because of that, the UK patent office set up, and UK was ruling, Britishers were ruling Indian country. In India, they started in 1856. In Germany, enacted a patent law in 1877, being the first such system in the world, with a mandatory examination. That is, after due examination, they will grant a patent. Early other countries, they will just see that, they will just put a stamp on that and they'll say, yes, we have granted. Now, Japan also started in 1885, and they had a very good patent system, utility model system in 1905. Now, we shall learn about Indian patent system. Indian patent system, as I told you earlier, because of the Britishers were ruling, it started in 1856. In the February 1856, 28, government promulgated a legislation called Exclusive Privileges for the Encouragement of Inventions of New Manufacturers. In 1856, George Alfred Depenning, he applied for a patent, what is called the first patent, efficient punka pulling machine. In the good olden days, we never had a fan. If I am sitting here, somebody will be using pulling the rope of that punka. The punka will be a big parda type fan. Oh, it will be just waving against you. So you will get a very good breeze and the air and everything. That was the system. Then we had the 1911 Patents and Designs Protection Act. They named it as a Patents and Designs Protection Act in 72. This was later on changed it as a Indian Patents and Designs Act in 1911, and it went on like that for about 10 years. Then first amendment took place in 1920, another amendment made in 1930, but it still continued as a 1911 Patents and Designs Act. Then in 1930, the special provisions like secret patents, whether there could be a patent of addition, is minor variation in the original patent. Now, should I apply for a patent of addition? The patent of addition will become addition to the original patent, for which you don't have to pay a renewal fee. And application fee alone will be made, examination fee will be there, and after that patent granted, it becomes akin to that original patent. When the mother patent expires, the patent of addition also will expire. And then the provisions for use of the invention, patent right by government. Then the law was very clearly paving way for controller's powers, and he wants to rectify the register of patent. Whether he can rectify, all these things were looked at, and then the provisions were made. And from 14 years, the original patent by earlier system was granted for 14 years, that they made it as a 16 years. Then in 1945, they had Justice Bakshi Tekchand, who was a retired judge from the Lahore High Court, Bakshi Tekchand committee to look into the patent system and then whether they can evolve a new patent system which is conducive to the national interest. Then They submitted the report in 1949, but somehow or other that could not succeed the voting in the parliament and it could not come up. Thereafter, in 1952, again they had their some amendments were made to the 1911 Act. They brought the provisions like compulsory license in relation to the patents, particularly in the category of food, medicines, insecticide, and germicide or fungicides, and substances like anything dealing with the surgical and curative diseases. And then the compulsory license provision also was started in that. But finally, in 1953, they tried for passing the bill, that bill what they introduced in the parliament, but they could not succeed. Finally, it lapsed. Again, in 1957, the Supreme Court Judge, Justice Rajagopal Iyengar, he was made as chairman of one committee, and then it was called Iyengar Committee, and they looked into the patent law provisions, and they gave the report with another 2-3 years, and that was finally passed in the year 1970. We had the new Patent Act 1970, replacing the original Patent Designs Act 1911, patent portion alone, and that patent rules came into force on 20th April 1972. And that is a patent system, Patent Act, during which, when it was in prominence, I joined the patent office. That old patent law provisions were very, very funny, different patent term for engineering item and pharmaceutical items, and license of right provisions were there. So many things, and then the patent was not granted for a pharmaceutical substance. Only the process could be patented, not the product. So all these points were there. And then India was a member of the GATT, GATT. When WTO came into prominence on 1/1/95, India was also a founder member. So India being a member of that WTO, when they signed the Marrakesh Agreement in 1994, finally the WTO came into existence on 1/1/95. India was taken as a most favored nation, and India was given 10-year transition period to make the law of the Indian country in line with the TRIPS agreement. So 1995 to 2005 was the 10-year transition period. We had the facility to change our law. Now, based on that provision, we had series of amendments made. That is the first amendment in 1999, second amendment in 2002, and the final amendment in 2005. This, with the amendment, everything, second amendment, we had the rules coming into force on 20th May 2003, and replacing that patent rules 1972, the 2003 patent rules came into force. The third amendment 2005, when it came, finally we brought that product patent regime also, which was not there earlier under the Patent Act 1970 for the pharmaceutical items or chemical items like that. Now, why should we have a IP protection? What is the use of that? First point, the IP right, intellectual property right, gives you a right, a monopoly, as a best tool for litigation in the court. If somebody copies, that right protects you, gives you the right to apply for a litigation, file a litigation suit against the infringer. And the court will see the thing, and finally grant a remedy, asking the infringer to pay the damages. May it be patent right, may it be design right, may it be trademark right, may it be GI right. This infringement portion is all looked into, handled by the High Court. Now, as a technical tool, how does it work? The patents, when you apply for a patent, you file a patent application with a specification. Finally, the patent is granted after due examination. The patent certificate is issued to you, then patent office keeps a patent document. That patent document gives you a latest technical information, which you will not get it in any other form of literature. So the patent document gives you the source of the latest technical information, so as a technical tool. Now, as a commercial tool, when you have the patent right, you will give the license to the person to start manufacturing. As a startup, you can take up the license and you can manufacture the patented product. And finally, you'll have to pay every year the royalty to the original patent holder. The patent holder may grant you an exclusive license or a non-exclusive license or sharing license, like that, mutual licenses, but it becomes a source for revenue. And IPR also works as an interface between creations and the rights. And you use this patent document as a latest provision. It also tells you what is the prior art, what are the problems they have faced there, and how they are obviated, how they manufacture. All descriptions are available. So you can use this patent document as a stepping stool for further innovations. So that is another, this works as an interface. Now, let us say patents, what it can give you. It conveys the most recent information, which you won't get it in any other form of literature. It has got a very good uniform structure, international format. Every patent office in the world, they have the same uniform structure. They have all sit together and they said, yes, this shall be the uniform pattern. Every patent office will follow. Then it contains the latest information, which is not available in any other form of literature. Then it gives you the clear abstract of the invention in a simpler form, not more than 150 words, so which you can easily go through. Normally, the patent specification may have about 50 pages, 100 pages, 150 pages. But abstract will be a small 150 words, small thing, which is published in the patent journal or the specification. And you have an international patent classification that gives you idea what is the latest, the international patent classification, through which you can access the various patents granted and what is your invention classified, where it is classified, what are the similar patents granted in that particular field. So these things you come to know, because that is the thing, international patent classification. It is formed by the WIPO, World Intellectual Property Organization at Geneva. And India also uses the same thing. Then the patent document gives you a bibliographic data, that is address of the patent, patent applicant, that is patent holder, name, inventor name, further data about his filing details. Now, the highest cost of processing the applicant, the patent documents, and classifying it is all done by the patent office. It is borne by the patent office, actually. You have to just access it and see. Now, I'm just showing you some patent documents. See, this is the United States patent document, US patent granted by the USPTO, and here you find numbers 54, 75, 73, 21, 22, 51, 52, 58, 56 and all. See, the patent document, patent has got a patent title of the invention, biodegradable toothbrush. And this is abstract. How many claims are there on which is a clear best drawing sheet, and what are the different patent documents cited against that during examination. What is the international patent classification? A46B504. This is US national classification. This is Indian and the US application number, and this is a patent number granted by the USPTO, and this is the patent date of patent grant. This is the European patent specification. They also have the same init codes. Okay, that is all the init codes. Numbers are same. It may be now. Luckily, it is in the English language, but there could be German patent, there could be the Swedish patent, there could be Russian patent. The numbers and this particular thing, everything will. This numbers init code numbers. They will show the particular data. That is the idea of it. See, this is a abstract, and the best the drawing that gives the invention details, that is published in the patent journal or the specification, for as an example for you to understand. Now you will have idea what is the Indian mode, Indian thing. That also I'll show you. Indian Patent Office journal, we make a notification. See, this is a Indian Patent Office thing. Here also we use the same 12 patent specification publication thing, filed in India, date of filing, then this title of the invention, same 54, method and apparatus for remotely operated electric fence, the applicant name, inventor's name, and then the international patent classification. Is there any patent application made outside India? Yes, there's a US patent file. Based on that, they have filed a convention application here in India. And this is the abstract, not exceeding 150 words. Number of pages are 26. Number of cases, number of claims are, how many claims are there? 13 claims are there. The Patent Office Journal, it is published on 16th June 2017. Now, these numbers I told you, init codes. Init is an acronym for international numbers for the identification of bibliographic data. Init codes are used by the Patent Office worldwide. Every patent office uses the same init code. So this is an international format. Indian Patent Office also uses same thing. So you only need to access and use. The classifying, processing, everything is done by the Patent Office, but you have to just use that, access the document, get benefit out of that. That is the idea of that. Now we will have a look whether patent is granted only for major technological breakthrough or any incremental inventions also can be patented. Now I take the example of the ballpoint pen. Laszlo Biro made an application for a ballpoint pen and he got a patent for that. That was a major technological breakthrough. See, you all may be knowing in 1920s when your great grandfathers were using the thing, they used to have a small iron nib. They'll soak it in the ink pot. They will start writing. Then thereafter, they had the fountain pen with like a reservoir type, and they will fill the ink. They will have a feeder and a nib and a feeder through which they will be able to use. They used to write. That is all gone now. We have a ballpoint now. based on the Laszlo Birol's invention. Now we have a very good ballpoint pen systems. The beverages can, they have a small cap. They have to open it with a thing and with a screwdriver or something like a knife, and they have to drink it like that. While drinking, it will spill on your dress and everything. To avoid that, they use the ring pull. They put the finger there and take it out, and that will act as a spout. They can drink. So that was an invention. So for every small incremental invention, you are able to get a patent. It is not only for a technological breakthrough, but any small incremental invention also is patentable. One more thing, when you come out with an invention, you also have to think about true market value. What is the demand for that particular invention? See, this is what is the thing. The next example I am giving you here, anti-theft device for motor cars. You don't read the word wheel clamp now. One UK inventor applied for a patent. He named it as an anti-theft device for motor cars. He manufactured, nobody was purchasing that. Then he thought, why the hell I took a patent for this? He sold the patent right, everything to the British police. They renamed it as a wheel clamp. And they made money. Now, Anand Dairy in Gujarat, they had that Tetra Pak carton for milk. But they could not make money out of that after having taken the patent right. They sold it to Godrej and they kept it as a fruit juice, Tetra Pak. They made a lot of money. So that is why I'm telling you, better to have a clear, true market value for my patent, demand for that. That will give you an idea. Now, let us say how you normally deal with the invention, with any invention. Either you make it public for free use, like publishing in the journal, or you work in secrecy without taking a patent, like Coca-Cola composition. What happened? It was there. Composition is a secret, and they used to manufacture. Nobody knew. Now, of course, it is open to public. When was it open to public? 8th December 2011. They made it public, open. Or the other way is work the invention openly without patenting it. Just directly put it in the market. I have come out with an invention. Now I am inviting the Honorable Prime Minister. He was on the Janmashtami day or the Independence Day, he will inaugurate and I will put it in the market. Now what happens? We have not taken a patent and you put it in the market, somebody starts copying it, and then you will immediately suffer. Arey, what has happened? Why he is copying? How he is copying? How did he come to know? Okay, he is making copying my invention. Okay, shall I sue him in the court of law? And you come to the patent lawyer and he will say, sir, have you taken a patent? What is that patent? You do not know. So best way is exploit the invention on the basis of patent. Like what the Rangzorov said. What did they do? They applied for a patent at every level. In 1960, they applied for a patent. They got a patent right for 20 years. 1970, they came out with another invention, incremental invention. They applied for a patent. It went up to 1990. 1980, they came out with another incremental invention about that same Xerox machine. They applied for a patent. It went up to 2000. So 1960 to 2000, 40 years, they were the pioneers in the field of Xerox machines. So that way, best thing is apply for a patent and then exploit the patent monopoly right. Now, let us have idea. I applied for a patent. what right I have, what is my right. In case of a patented product, the patentee shall have exclusive right to prevent third parties, anybody else. So it is a form of a negative right. The other party cannot make this invention. Other party cannot use this invention. Other party cannot offer it for sale, or they cannot sell it, or they cannot import it from outside India. In these cases, it will be taken as an infringement. If it is a process, the patentee shall have the exclusive right to prevent the third parties from the act of using that process, from the act of using it, manufacturing, offering for sale, or to sell it, or to import it from other country. All these rights are vested on you on the date of grant of patent to you. Now, let us understand. The patent right is given to you. What is the outcome of the patent right? The requirement of the patent right, once it is given to you, you are expected to disclose the full subject matter of the invention. So that is what is given here. Requirement is full disclosure of the subject matter. What is the result of that? You get your monopoly right for your invention. The diehards say you give the patent information, then we give you the monopoly right from the right arm. So you get for an exchange of technical information. Outcome of the right, exercise the monopoly right for the patent term. What is the patent term? It is granted for a 20-year period, because that is the thing used when the WTO started on 1195. They said you will have TRIPS agreement. Under the TRIPS agreement, it was made very clear patent term shall run for 20 years from the date of filing. And that is the thing granted. 20-year patent term is granted by the USPTO, by Japan Patent Office, European Patent Office, Chinese Patent Office, Singapore Patent Office, Australian Patent Office, or Swedish Patent Office, or Indian Patent Office. Every country in the world, now they have switched over to the WTO arrangement, TRIPS arrangement. Finally, the patent term is uniform, 20 years from the date of filing or from the date of priority. When they are asked, now I showed you Indian case, a small that electric fence. They filed an application here in India. I mean, they filed an application in the United States, and that based on that they filed a convention application in India, and that was coming for from the date of priority. It will go for 20 years. Now you are not able to manufacture. You got a patent right. What to do? How to make money out of that? Best thing is outright sell it or give compulsory license. Give compulsory license and get royalty. What is the effect of that? You will get a huge return of investment for your invention, because you are giving for compulsory license. That person will manufacture. You may give only an exclusive license or a non-exclusive license, and they will pay you royalty every year. The important thing, what you have to remember is, monopoly right ceases to exist after the term of patent. 1/1/2000, the patent is granted to you. When you filed application on 1/1/2000, the patent right will go for 20 years. That is 1/1/2020. Answer 21, because 2020 years, 21. So that way, 20 years per term is calculated to the thing. Now, I give you some examples. This Wipro Technologies, they use the IPR strategy for protecting the patented inventions. And they had in 2009, that IPI right values, strategy values were taken as 180 crore. In financial year 2015-16, the company continued to strengthen the IP portfolio, and now they hold about 1,085 patents to their credit. The New York University earned $157 million in 2006 as a royalty for having made the inventions and given it on compulsory license. Stanford University in 2006, they earned the royalty as $62 million through licensing. Washington University in St. Louis, they in the year 2008, out of the 94 patents they had taken, they had given 42 patents for licensing and earned $17 million. University of California, they generated revenue through licensing to the tune of $48 million in 2007, from 5 patents which they have given for licensing. Ohio University, they had as a royalty income $8 million in 2010, which the license they gave it to Pfizer Corporation for the growth hormone receptor antagonist technology that became the basis for the drug Somavert later on. According to Ernst & Young Company, their income from patent licensing increased from $110 billion in 2000 to $500 million by 2015. See the thing, how they are able to use the IPR as a revenue commercial tool and make money out of that as a very good return of investment. The Stanford University, out of that, they filed more than 300 patents. They had only produced great spin-out winners like Google, Sun Microsystems, Silicon Graphics, Netscape, Cisco, Yahoo, and everything. Now, through licensing, how the different universities, organizations in USA, they made money. For example, IBM, $1.7 million they made. Texas Instruments, $500 million. Stanford University, for the licensing given, they have made about $37 million. Take the Indian company, Dr. Reddy's Laboratories in Hyderabad. They started in 1984 with a bank loan of $120,000. The first international patent they made in 1995. By 2011, they made about 300 patent PCT international applications. And it was the first pharmaceutical firm to be listed in New York Stock Exchange. It went up to the first high level. Now, between 2000 and 2010, the revenue of the company rose by about 25%. Royalty earning was more than $2 billion. In 2007, revenues reached $1.5 billion and recognition as the #1 pharmaceutical company in India in terms of turnover. That rose to $1.7 billion by 2011. Patents and licensing were the contributing factors. So you have to take a patent, you have to manufacture, get the return of investment, or give it for licensing, get royalty, and be the front runner in the field. My advice is, your ideas, if they are worth copying, then 100% it is worth protecting. Now, the next topic which we have to see is the trends in IP filing in India. That is why I given this slide. The last 5 years, the patent applications, I am giving the data, the data now, statistical data, because the latest annual report, which is given 2017-18, given in 2019 last year, I have taken from that patent. It has increased steadily in a very progressive manner, 42,951 to 47,000 applications in the year 2017-18. Design applications from 8,533, it has gone up to 11,837. Trademark applications, 2 lakh applications to 2,72,000 applications. Geographical indications, it has increased, again decreased, then again increased. In fact, whenever the Controller General, we surpassed the UK GI registration. And ours was a maximum. Indian Patent Office was the first thing to grant more than 150 GI registrations within a period of 2 years. The Copyright Administration shifted to DIPP in 2016. 2016, we had about 16,000 applications. In 2017-18, it has gone to 17,841. Now, filing of patent application has increased. From this data, you can see 5.3%. Domestic filing has increased from 32.5% from 29.2% in 2016-17. Number of patent applications examined increased to more than double, 108.2% increase over the previous year. Grant of patents increased 32% and disposal of applications increased by 57.6%. Now, to avoid the creation of backlog or the accumulation of backlog of applications, the new order has been issued by the Controller General. That is, examination will take over will happen anywhere in India. So whichever office having a lesser load, the examination duty will go there, automatically be examined by that office, and you will get applicant will get a examination report. And you can file it in the application where you have filed. Suppose you have filed in Calcutta office, the application may be examined by a Chennai office or Bombay office or a Delhi office. The report will come to you. But the resubmission, you can file it in Calcutta. Now your company is in Ahmedabad. You come under the Bombay jurisdiction. You file the application in Bombay. It may be examined by Delhi office or Calcutta office or Chennai office. You will get the examination report. But you can resubmit the documents in Bombay office. That is the idea about. That is to reduce the backlog accumulation. Now I am giving you the examples of patents. Now it is about the furniture caster wheels. How these are all the subject matter of internal mechanism of the caster wheels for the furniture. Examples of patent. And this is about the quadcopter drone, a patent granted by the United States Patent Office for a applicant. I'll give you about the design examples. The tire treads, that is also a design subject matter. Electric jug is a design matter. Swiss multi-purpose knife, that is a design subject matter. Designer's chair, that is a designer's design subject matter. Now coming to the example of trademarks. Trademark, what is a trademark? It is a sign which can distinguish the goods of one trader from those of another. The trademark sign includes words. It could be word or a logo or a picture or a combination of all these things. Example, Sony camera, Olympus camera, Canon camera, that old box camera type. So to register a trademark, the mark must be distinctive. It should not be deceptive. It should not be contrary to law or morality, and not identical or similar to any other earlier registered trademark. Well-known trademarks, or these are all the well-known trademarks: Coca-Cola, Toblerone, triangular shaped chocolates, and then Rin, logo for washing powder made by Hindustan Lever, Annapurna, salt by Hindustan Lever, Lipton logo, the tea, that is the thing. This is about the geographical indications I am giving you now. Few examples of geographical indications. Now, for example, Mysore silk, Kanjivaram silk, Namma Mysore Park, that is again GI registered. Nanjangudu, Rasavalli, banana. Kolhapuri chappal, which is registered. Mysore sandal soap is also registered. Mysore Badnekai, that brinjal. Mysore Mallige, that is also taken as, because the unique product of the Karnataka state. Dharwad Peta, that is also GI registered now. Channapatna toys, very, very famous in Karnataka. Tirupati Laddu, that is also GI registered now. Guntur chilies, Hyderabadi Halim, that biryani. Panayor Pavitra ring, that is also GI registered. Kesar Junagadh mangoes, Kesar mangoes, the Junagadh mangoes, that is GI registered. It's all the national heritage products for which we get the thing. Now, I will see some of the case laws to give you an idea. What is that? This is a case law, Anasar Chinna Dastagiri Sahib versus Maduleti Buggappa. The question was, an illiterate person can be an inventor. Well, in that case, the patent can be granted or he can execute. The law does not bar you. The law does not stop you. You need not be a graduate, you need not be an educated person, you can be an illiterate person, but you can, if you can sign or you can put a thumb impression, then you can get a patent. The Madras High Court, relying on a Lahore High Court decision, observed as under. An illiterate who can only sign his name in Telugu and do nothing more can apply his mind to the various gram frying processes, and a machine for that, and invent a machine more useful than existing machines by its minor improvements, very, very trivial improvements, trivial incremental inventions, and the new combination of making that machine better machine, that is a patentable subject matter. And they have granted. If the result is to produce the article either greater yield or cheaper in cost or better in quality, that will do. Then you will get a patent. He is an illiterate person, that is not a bar. Age is not a bar. Anybody can be a thing. I am an electronics graduate, but I can do invention, carry out inventions in the field of mechanical engineering. A commerce graduate, an economics graduate, he has come out with a very good heat exchanger. So like that, qualification for education is not a criteria. Now, this is a very, very peculiar thing, the case law 2. This is an invention, the application for improved threshing and separating machines. The applicant, Mr. Mani, applied for a patent, got the patent, and he made a infringement suit against Manivannan. Now, applicant, I have said here, applicant is for the revocation application. What you see here, original revocation application, who he filed in 2007. Why he filed a revocation is Mr. Manivannan in the year 2000 he made an application for a machine for threshing corn, and finally he did not. And the patent application was examined by the patent office. Patent office issued the patent examination report, but he did not. Mr. Manivannan did not resubmit the document. Finally, the application was deemed to have been abandoned under Section 21 of the Act. So he didn't get a patent, but he was manufacturing his machine. Probably the same technology with the improvements, more improvements made in that amendments, various modifications made by Mr. Mani. He applied for a patent in 2007 and he got a patent for that 2,04,322, the patent number. When he filed an infringement suit against Mr. Manivannan, instead of going for revocation, counter claim for revocation in the Madras High Court, what he did is Mr. Manivannan filed a revocation application in the appellate court. So he is called as an applicant for revocation. That is a number is given as the ORA 3 of 2007 for patent side. The matter was listed before IPAB and which held there was no provision for withdrawal of patent application till second amendment. Now, prior to this new amendment, second amendment which took place in 1999, under the 1970 Act, you can file application, but if you are not interested in getting a patent, you can't withdraw. But that provision has been brought in Second Amendment, which came into effect from 20th May 2003. Now under the amended Act of 1970, you have a facility for withdrawal application. When Mr. Manivannan filed in 2000, the old law was enforced and there was no withdrawal facility. Because he could not withdraw, he allowed the application to go for abandon because he didn't want to get a patent. Now what has happened is he started manufacturing. This person with more improvements, more changes, modification made. Mr. Mani applied for a patent, got a patent, this 204322, and he filed a suit against this Mr. Manivannan in the Madras High Court. Now this Mr. Manivannan said this invention, what is claimed in this 204322 by Mani, the patent holder, is already claimed in my patent application. He said this application is lacking invention due to prior claiming. What is prior claiming? Subject matter of respondent subspecification must form subject matter of distinct claim in cited specification of the applicant. It is not sufficient if the claim is merely comprehended in the subject matter of a claim in the cited specification. The comparison must be made between the two claims, that is Mr. Mani's application and Manivannan's application, and it should be exactly same. If that is not there, then it cannot be a matter of prior claiming. He failed there, and finally because he could not prove that prior claiming, and finally the IPAB refused to allow the thing and refused their application for revocation. Now, what happened? IPAB held that the applicant had not shown how the respondent, Mr. Mani's claim was equivalent to his thing. Further, his patent application was abandoned under Section 21 of the Patent Act. Before taking the decision, the IPAB said respondent application is not anticipated by prior claiming. It should be proved beyond doubt actually. By respondent claim is similar to the applicant's application, showing that the invention is distinctly same as stated in his specification. If that is not so, anticipation by a prior claiming will not exist, does not exist. Moreover, on detailed analysis made between the two claims by the IPAB, there are a lot of the differences in the constructional features, and that is the reason why IPAB refused the revocation application. Now what happened? Finally, this Mr. Manivannan went for appeal in the Madras High Court. That is what we say, IPAB rejected the revocation application. Now applicant filed, this Mr. Manivannan filed a writ petition against the judgment of IPAB in Madras High Court because there is no provision for appeal against the order of the IPAB. If there is a point of law wrongly decided by the IPAB in a point of law error in judgment, then they can go. So the only way is now to file a writ petition in the High Court saying that IPAB has erred in judgment. Like from High Court to Supreme Court, our judgment by IPAB can go only in Supreme Court. So they made a writ petition in the Madras High Court, and then he again, the petitioner, again argued the same anticipated by prior claiming, citing his own case, what he filed in 2000, how our IPAB has erred, and he also said that Mr. Manivannan said the patent granted is only a mere arrangement or rearrangement of my application, my invention, and the court held the novelty is necessary in the process of manufacturing and not in the article produced. A novel combination of two known ideas can prove for novelty of subject matter. Appellate Board had pointed out the difference in constructional features and distinct factors in the judgment. Further, the Appellate Board has opined very clearly that patentee has specifically characterized the inventive features in the principal claim, defining the scope of the invention, and observed that the petitioner document does not anticipate respondent's claim. Court held that the revocation application was rightly dismissed by the Appellate Board, and the judgment in dismissing the revocation application is free from any flaw or legal infirmity. Hence, the writ petition fails. So they dismissed the petition. Now, I want to say one more thing here. This IPO website, www.ipn.nac.in is a thing. My email ID is iprsakan@gmail.com. Any questions, always you can come there.